Sunil sir, we can start, sir.
Yes, sir. Respected convener of this program, Dr. P. Sri garu, Head of the Department, CSE, Shri Vishnu Engineering College for Women, Bhimavaram. Today's resource person, Dr. Deepak Joshi, and my dear faculty members. Good afternoon, one and all. In this great day, I welcome you all for the Impact Lecture Series in association with AICTE, Institution Innovation Council, and MHRD's Innovation Cell, Government of India. Before entering into the session, I like to invite Dr. Deepak Joshi, sir, from the Department of CSE, Shri Vishnu Engineering College for Women. We thank you from our bottom of our hearts because despite of your busy schedule and in this weekend, you spared some time in your calendar for us. Really, we are blessed, sir. So thank you so much for joining with us, sir.
Thank you.
Sir, before entering to the session, I would like to take the privilege to introduce you, sir. Dr. Deepak Joshi has a PhD in management and is UGC Net Management qualified. He has done FDP from IIM and holds the degree of Master of Fashion Management from NIFT. Dr. Deepak has over 15 years of experience in corporate and academics. Previously, he served in FDDI, Ministry of Commerce and Industry, Government of India as senior faculty retired. His other significant stints include serving Future Group in various roles such as brand relationship manager, assistant mall manager, and store manager. His academic interests include business analytics, e-commerce, research methodology, and IPR. Dr. Joshi has been the unit in charge IPR unit of NIFT, and his role includes facilitating IP protection and promoting IP sensitivity at NIFT. He has been invited as a guest speaker on the importance of IPR and digital commerce, etc., in Central University and other leading institutions. He has actively been involved in projects having social and cultural impacts and currently involved in a project on sustainability with UNEP. Sir, now I request you to enlighten us in filing a national and international patents and understand the procedure for the same.
Thank you so much, sir. And I'm extremely thankful for your college and Dr. P. Sri for inviting me here and giving me this opportunity. And I hope that I'll be able to do justice to what has been entrusted on me. I hope the presentation is visible.
Yes, it is.
Yes, sir.
So we'll be talking about patent, its importance and protection. To start with, let us just have a look at what it is all about. So as you all might be knowing that in today's time, intellectual property is of paramount importance. And as per WIPO, it is the property that arises out of human intellectual effort. It can take many manifestations. So it is not just patent, it can be manifested in many other ways. WIPO says that the creation of mind could be in various forms. It could be in the form of inventions. It could be in the form of literary or artistic works, designs, or symbols or names and images that we use in our industry or in commerce. As per WIPO, all intellectual properties have been divided into these 5 types. out of which 4 has been indicated as industrial rights because they have an industrial application, while copyright is a right granted for literary and artistic work, and that's a separate right. So we have patents, which is granted for a new and non-obvious inventions, trademarks, which is generally a combination of name, logo, term, font, or any which way, a combination of all these which demarcates a product or a service from a specific manufacturer or a producer or even a person. Industrial design are in an addition to that, which indicates uh, manifestations of your ideas in a form of visual appeal. So whatever appeals to your eye could be either manifested in two-dimensional things or three-dimensional things. So if it has a design which appeals to eye without taking into consideration any technological or working aspects, those could be protected as industrial design. Whereas if they have a working aspect, then they are protected as patents. Trade secrets and patents many a times go hand in hand. Why I say this is because we'll talk it later, that an alternative to patents could be trade secrets. So if you have certain important aspects which gives you competitive advantage over others, probably in spite of registering somewhere, you can make them as a secret so that they does not gets divulged out. You need to protect them, and you make certain resorts to keep them protected over years. That's how they are termed as trade secrets. If they are, so as we know that if a secret is lost, it is lost. In the similar way, if you do not make provisions to protect it, then these could be lost also. Legally, if somebody is able to take them out, you don't have anything. Then we have geographical indications. These are rights granted for a specific geography for specific products or produce. So these have been protecting our various products and produces in terms of agricultural produce as well, where many of the counterfeit products were coming into the market. So, for example, we have Banarsi sari, Korapuri chappals, or Kanjivaram saris. So, for a Kanjivaram sari to be called as Kanjivaram sari, now somebody will have to get that manufactured within Kanjivaram or otherwise. Otherwise, people had started making them in certain other places as well. So people associated with that particular craft or produce were getting demotivated. They had to leave their jobs or their art because there were many counterfeit products. So in this way, this geographical indication assures that if a product has a specific quality ingrained due to an environmental condition or a geography over there, or the specific skill set of the people living within that area, then that is awarded a geographical indication. So that is restricted to a specific location, and specific people who get an authorization license, they can make it. So if somebody wants to make a Bikaneri bhujia now in, let's suppose, say Hyderabad, he can always make it there, but they will not be able to make it, call it Bikaneri bhujia, because to be called it as a Bikaneri bhujia, it needs to originate in Bikaner, so that it gives a thrust to that particular area. So having said that, we'll move on to what we are supposed to cover up today. So we'll be talking about patents, but just a little into that, why protect them or what all these IPs gives us. So IP in general term are really necessary for the progress and well-being of humanity. And safeguarding of IPs promotes further innovation. It spurs economic growth and ultimately adds value to the life of the people. And this, when we say which adds value to the life to the people, has a connection with patent that we'll talk a little later. So all these IPRs reward creativity and human endeavor, which fuels the progress of humankind. And in today's time, we must be using many of the patents which were invented by someone at some particular time. Now they have made our life easier. Starting from which we daily use a ballpoint pen, or let it be certain medicines or the uh, vaccines that we have been using were patented by or invented by someone. Bulb that we use today was invented, as you might be knowing, by Edison. So somebody took pain to evolve all these things, and we are reaping the benefits. One of the latest example could be the Covaxin that was manufactured in association with the government of India. Government of India is one of the shareholder within this, because it facilitated Bharat Biotech to evolve that Covaxin. And India led the campaign to waive intellectual property protection on coronavirus vaccines so that world over people could be saved. So having IPs, you'll find that gives a thrust to economy, and even if it is an institution or a country or even a company, you'll find that all those who have secured the IPs are on top, be it a company, organization, or be it a country. So from the perspective of patent, in general, we know that it is a right granted for an invention. And this is as per the Patent Act 1970, Section 2 by 1, which says that patent means a patent for any invention granted under this act, which further elaborates in Section 48, which says that it is the exclusive right granted to a patentee to prevent third parties who do not have his consent from the act of making, using, offering for sale, selling, or importing for those purposes that product in India. So this patent legislation within India is controlled by Indian Patent Office, which is administered by the Office of the Controller General of Patents, Design and Trademarks, which is generally known as CGPTDM, under Government of India. And office of CGPTDM is in Mumbai. However, the patent office is headquartered in Kolkata, while it has branches, 4 branches across Chennai, New Delhi, Mumbai, and Kolkata as well. So the jurisdiction of a specific patent office covers that particular zone. For example, I'm sitting over in Delhi. So Punjab, UP, Uttarakhand, Himachal Pradesh, and even Delhi has. So Delhi Patent Office has that jurisdiction. So if in case I want to apply for a patent, I'll apply to that office. So trademark and patent office, all that is situated here in Dwarka, what we call is. So probably I had visited one of the office that is in Chennai. So yours probably the zone which lies jurisdiction would be Chennai in that terms. So any application in terms of trademarks or patents will have to be applied to that particular office. So Indian patent has evolved over a period of time. So the most elaborated act is the Patent Act of 1970s, which actually came into the force in 1972. However, we had certain laws which were devised by or adopted from the British patent law. So starting from 1856, where the protection of inventions based on the British patent law of 1852 was taken forward. And again in 1859, it was modified. However, the most significant is the Act of 1970s, which has been amended over a period of time in 1999, 2002, and 2005. So the main reasons for uh, amendments after around 1999, 2000 and 2005, where that India became a member of WTO. GATT was replaced by WTO in 1995. So this is a controversy. Many a times people say that IPs were forced on certain countries. Before that, many of the countries were doing, in terms of patent, reverse engineering the products and adopting those technologies without any rights. However, this General Agreement on Trade and Tariffs was replaced by WTO in 1995, and trade-related aspect of intellectual property rights, what we call as TRIPS provisions, were signed, and India is a signatory to that. So it said that all the countries need to have a safeguard for all the members of WTO, or who are the signatories of TRIPS at least. So they need to protect or give the rights to the people or the organizations of the other nations in the similar way as if they are the nationals of that particular country. So they need not to discriminate in terms of how you apply or in terms of the protection that is granted to a national of that particular country or a foreign national in that terms. And there were certain specific provisions within TRIPS which demanded that within certain time frame, all the signatories to TRIPS need to come to a same platform. So 2 years, around 1 or 2 years were given to the developed nations. So they said that till 1996 you need to abide by the same. 2000 was given to the transitional economies, and the others underdeveloped nations were given some more time. So India, in a promise to upkeep with that TRIPS, made many provisions or amendments in various IPR laws. So you must have seen that Design Act 2000 also came with respect to it. So in the similar way, the amendments, whether we say 1999, 2002, 2005, were incorporated to get aligned with TRIPS. And patent rules have also been amended over time and again. Latest have been done in 2021, and they have been really making, or government of India has been making an effort to make the filing or the process of patenting quite easier, facilitating people so that they do not find it troublesome, and even making certain other provisions that will have a look a little later. I hope we are going, the pace is fine.
Yes, sir.
Right. So certain features of Indian patent laws are or act are like this. So they have now incorporated comprehensive e-filing. So till some point earlier, it was supposed to be filed physically, and after that, e-filing was made, where one needs to have class second or third digital signatures to file an application. But over the time, now they have done a further advancement that you can get an e-signature also. So difference between the digital signature and e-signature is that for digital you need to carry a dongle to authenticate, whereas e-signatures are digitally OTP based. So as we sign our many a times you must be verifying yourself with Aadhaar with an OTP. In the similar way, your e-signs could be verified by using an OTP. So e-Mudra is one of the facilitator which Indian Patent Office, what we call as IPO, has tied up with. So for filing an application, you need to create your login ID with the IP website, and then register yourself for the e-signatures, or probably you can afford going for digital signatures as well. But e-signatures gives you a liberty that you need not to carry that dongle. And then you register yourself, and then you are able to find all the applications which we'll be talking about, that what are various applications, through e-filing format. So you need to fill those forms and upload it. So it has become quite easier. Or otherwise, you can send the physical copy of the application to the office, or you can go yourself submit it. So it's quite easy. The term for patent protection is 20 years in India. It has to be 20 years. After that, it comes into public domain. So as we were saying that all the patents actually help us in uh, adding value to our lives. So certain patents that we were talking a little back, for example, whether it is a simplest a ballpoint pen. Now we easily one can find in 2-3 rupees, and even a person who could not afford a very good ballpoint pen, he can get in right with a 2 rupees ballpoint pen. So someone at some point of time thought of it, invented it, and later it came into public domain. So nobody has a right over it. Similarly, we even if we talk about TVs or any inventions, they have fallen into public domain so that anybody can take. So this is the maximum time frame till one can reap the benefit of a patent. So until unless you reap any benefit, that has got no use. Another important aspect is examination on request. So all the patent applications that you file needs to be examined by the patent authorities. We'll talk about how this examination is done a little later. Uh, in India, it calls for submitting a request for examination. So if you do not submit a request within 48 months of filing an application, that application is deemed to be abandoned. So you need to request for examination. One of the beautiful feature of Indian patent is that it has got both pre-grant and post-grant opposition. Pre-grant means before granting a patent, one can oppose. So it is one of the beautiful aspects that even before granting a patent, it could be opposed. Whereas if we talk about US patents, they have got only post-grant opposition till now. Post-grant means that once granted, patent has been granted. After that, somebody can file an opposition. And that was the case when I think you must be aware of that. Once US a patent for use of turmeric was filed in USA, medicinal use of turmeric. Similarly, basmati was protected by a company called Texamati. Sorry, in the name of Texamati, a Rice Tech was a company which took a patent. It was granted to them, but some of the people and NGOs from India, people raised their voices and opposed it, and then these uh, patents were revoked later on after granting it. So in India, it is a better thing that one is given a pre-grant opposition as well as post-grant. So in this term, this is a little advanced thing that nothing bad can be patented in India in that terms. In Indian patent, we have provision of protection of biodiversity and traditional knowledge. So traditional knowledge, the knowledge that flows from tradition. So you must be knowing that many of the medicinal uses or medicines that your grandma or grandparents might have told you, you must be using it. So those kind of knowledges or certain other things could not be patented, because government of India has also taken a step of updating and creating a traditional knowledge digital library, and that is connected to patent information system, and the information is cross-checked. But as you know that in US earlier previously use of turmeric was granted a patent. So in India, this is duly acknowledged and taken care of. In India, once you file an application, it gets published. That's how you get a chance to oppose it before grant of a patent. And this application is generally published within 18 months of your filing the application. However, as per newer provisions, it could be fast-tracked also. If you want an early publication, you can go for it. So there have been certain provisions through which the timelines have been reduced. So when we want to know what is the patentability criteria of India, and I like to give you an importance to the words which have been what to say highlighted over here or have been made bold. So as per Indian Patent Act 1970, which has been amended over time to time, its section 2(1)J says that invention means a new product or process involving an inventive step and capable of industrial applications. So we get three keywords over here: new product or new process. So to be patented, either it needs to be a new product or a process. Further, there needs to be an inventive step to arrive at it. And it must have industrial application. We'll look at what inventive step and industrial application talks about. Section 2(1)JA, this section 2(1) just JA was introduced by Amendment Act 2002. Inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance. So if you are inventing certain things, it needs to be technically advanced than what is actually existing today. So if you have made certain thing which is doing the same job which is being done by other thing today, probably it might not get patented. And it needs to have economic significance. Economic significance can only be there when it has got use. So although we do not specify the term utility, but this economic significance word automatically chips in that utility. But certain other offices or the patent regimes for US and UK, they say that utility has to be one of the requirements of patentability. But in a terms here also that utility perspective is coming in, and it also says that or both, and that makes the invention not obvious to a person skilled in the art. So another beauty is that it says that that invention or that inventive step must not be obvious. So what obvious means is, as per patent act, that a person who is reasonably skilled in that particular art, he should not be able to easily say that okay, it could have been achieved like this. It should not have simply come to his mind, a person who is skilled in that particular profession. Then another section 2(L) of Indian Patent Act says that the new invention, as any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. So it says that it will term new invention as the one which has not been published anywhere, documented everywhere before you have filed your application. So the knowledge or intent of doing such kind of things should not have come into the public domain prior to your filing of the application. So if it has already been done, then probably whatever you will do, even if you will file, it is not going to get a patent. With this, when we look at these three sections, we will be able to make out the patentability criteria of India easily. So as I say, that somebody may use different terms for it, but they are exactly based on these sections of what patent law says in India, Patent Act 1970. So we saying that a product needs to have newness or novelty. So as we just discussed, it needs to be a new product or process, needs to be preserved. When we say newness, just now we talked about in public domain. So how it comes in public domain? It comes in public domain, somebody publishes it, or many times you may also publish it, or you may also disclose it even in, let's suppose say in a seminar, or you are too excited and you wrote a research paper on that and you made a presentation to a group of people who are participating in a seminar, let's say. So you have publicly disclosed it. So if it has been already publicly disclosed, there is no newness and novelty. So being an inventor also, we need to identify that if somebody has got possibility of protection, we need not disclose it and take certain measures to protect it. And second, non-obviousness that we have already seen. So we are just listing the criteria that we identified from the sections of the Patent Act, because Patent Act does not immediately says that patentability criteria there is 1, 2, 3, 4. It is not saying. It is talking in terms of sections. So one, newness, novelty, and we need to understand that what is all about. Second is non-obviousness, that people reasonably skilled in that particular art, craft, or in that particular area should not arrive at that invention that you are saying easily. They should not be able to say, oh, okay, it could have been done. Then third is inventive step or usefulness. So we are saying that somebody may say or write somewhere that it is utility also, but it is not directly indicated as utility in the Indian Patent Act. It says that it needs to have advantage over the existing. So it means that invention which is of no use to mankind, or probably there is no utility of that particular, may not be granted a patent in that way or a protection. Another term that we were able to coin from this was in section 2(1)(j) was industrial application. So industrial application indicates which is capable of being made or used in industry. Either it should be able to, you should be able to make that particular thing in industry, or it should have an industrial use. So either if something is having an industrial use, that is going to have an economic value, or if something is able to be made in industry, probably again it could be given to the masses in that way. So these are the patentability criteria which we have derived out from the Indian Patent Act. Whereas you must be saying two others in the last line, which have been set to as patentability criteria by USPTO, US Patent and Trademark Office, and the Europe. So in US it says that novelty, non-obviousness, and utility, whereas novelty, inventiveness, and industrial application is set by Europe. But you will find that while elaborating all these three things, it will cover up whatever we have talked about. So in general, all patent offices across the world will be looking into all these things. So which we talked right now. Probably they may not name it directly, but they will be looking at that the process or the product that you have achieved, it needs to be new. It need not have been published previously. It need not be non-obvious or obvious, sorry, and it needs to be useful or needs to have an inventive step or needs to have certain advantage over the existing things. And another thing was industrial application. Patent Act also talks about certain exclusion which could not be granted. So we're not talking about all, but certain important things. So this is the beauty that it talks about that which cannot be granted. So when we say which cannot be granted, I need to understand that while I am making an application, I need to cross check, or probably if I am inventing, I need to cross check whether whatever I'm writing, can it fall into all these domains? Because the way the language I might be using, or the probably the invention, the way I would be explaining my invention, probably in a hurry you may use certain things. So I need to understand that if I'm inventing certain things, they need not to be a part of this. So certain frivolous inventions which claim certain things which cannot actually be. So inventions contrary to the well-established natural laws may not be granted a patent. For example, if someone says that the efficiency of my machine, previously a machine that has been patented has got 98% thing, my machine gives 100% performance. So probably 100%, you can say 99, but 100% cannot be there. So again, another section 3B says that, so this complete section of 3 is about what cannot be patented. Another 4, 5, there are other sections which also talks about which cannot be patented in the Patent Act 1970. So Section 3B of patent says that intended use or commercial exploitation of which could be contrary to the public order or morality. Certain things which are not in order of public morality or which may cause serious prejudice to human element of plant life or health or environment probably may not get patented. So if you are devising certain things which has got these kind of hazards, probably it may not be granted a patent. Again, the section 3C says that the established laws or discovery of not established, the discovery of laws or theories or uh, living discovery of any living thing, probably one can name it on himself or herself. There are convention IUCN and there are many other conventions which gives name on the basis of who has found out in biology or in chemistry and all. When you find out an element, let's suppose you found out some new species, so that you cannot patent that species in units. You say that okay, I went to the Himalayas and found out a new butterfly and I will get a patent. No, so that is not allowed. Section 3D is an important aspect which says that mere discovery of a new form of known substance or a process which does not result in enhancement of the known efficacy. So as we were talking previously also, that if your invention is not making any efficiency over the existing things, probably it may not be granted a patent. Again, discovery of any new property or new substance per se, not only the property of this but a new substance or the process or a machine or apparatus and may not be protected until unless it has got something new in it, probably a reactant or a part, anything. So if it is completely as such that which is already existing somewhere, it will not be granted a patent. Other exclusions as per Section 3 of Patent Act are that the mere arrangement or rearrangement of duplication of known devices, each functioning independently of one another, is known in a known way. So probably you have a computer, you have certain sensors and a display machine. So you say that I have found out a system which will track your BP monitor, send it to the doctor, and will automatically order the food for you morning. So you need not worry about that. You have an app, you are wearing a wristwatch which is collecting your data, and that is probably sending signal of your heart rate, probably all other medical functions to your doctor, and he's recommending certain other things. He recommends something, and the similar app orders to an app which is delivering at your doorstep. So probably in the next morning, you have a ready-made food or probably ingredients delivered to you. So somebody says that, okay, I'll do that. Probably that is not going to be patented because we are combining 2-3 already known ways. We know that there is a smartwatch which connects this. We have certain things that one can order through an app. They can set timings to be ordered on the probably today, tomorrow, or whatever it is. You can always do that. So we need to understand as an academician more particularly, because you must be dealing with many students and all that, what can be patented and what cannot be patented. Again, a method of agriculture or horticulture cannot be patented. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, or any process of a similar treatment of animals. So somebody operates someone and says that I have done it in a new way, and then nobody can do it. So that is not allowed. So again, plant and animals in whole or any part thereof, other than microorganisms. And again, a mathematical or business method or a computer program per se or algorithm. So I was looking at that many of you must be from the computer science background and you must be dealing with many algorithms. So simply algorithm cannot be patented. So you need to combine it with something else, then probably it will get patented. So these are all sections of section 3F, 3H, 3I, 3L, 3K, all these. So a thing which can be registered as an artistic or music or literary work, or has got aesthetic nature, and but does not have any working thing in that way, that cannot be patented. Again said that this section L also talks about the traditional knowledge will not be patented. Section 4 and 5 deals with invention related to atomic energy, which cannot be patented. And again, inventions where only method or process of manufacturing are patentable now. Previous, as I was saying that this TRIPS, before the onset of TRIPS, India was not granting process patent. So only in medicine it was provided process patenting. That too was for around 7 years. But now with this, we were signatory of TRIPS, so we had to give this protection to all that, even in all the inventions. Even if you are able to reach to a particular product through a new process, that process can be granted a patent. So process patenting is allowed in India through this section 5, which was previously under exclusions, and now this has been omitted under the Amendment Act 2005. So any confusion as of now?
No, sir.
Right. So now there are certain safeguards in Indian Patent Act. So Section 100 talks about power of central government to use inventions for the purpose of government. So if government wants certain inventions which you have done, and they say that, okay, we'll not let you have that, they can acquire that patent. So Section 102 talks about acquisition on invention and patents by central government. Of course, it talks about that compensating the another entity which has got that patent, but our central government can take that patent from the patentee. And there is another component called compulsory license to ensure availability of drugs at reasonable prices. So this happens many a times that if there is certain emergency, even this is indicated in TRIPS, if there is any emergency, as per Section 84(1) of Patent Act of 1970, any authority or judiciary may allow without permission from inventor the license to make that particular, it could be a medicine or something else. So a government can acquire and immediately give that license to somebody else. Okay, you start manufacturing it. So in case of any national emergency, government can deal with. So there are certain provisions to deal with public health emergency intact in our Indian Patent Act. And it can also revoke certain patents in public interest. And also if certain patents, if sees that it may have certain security considerations. So now when we apply for a patent application is a simple patent. Based on that, what we are doing within that application, it can be called as an ordinary application, convention application, PCT application, divisional application, or patent of addition application. So these are types of application. Application is the same. What we are doing indicates that what is happening inside. So an ordinary application is an application which you are directly filing for protection in the patent office without anything. So today you found out something and you want to protect it, you go and file an application, ordinary application, you need not worry. But let's suppose that somebody has already filed an application in certain country. Foreigner want to file here, or probably you want to file an application outside. So convention application, there was a Paris Convention which led to the internalization of protection of patents. So there are many countries signatory to it. So if you want to file or protect within that particular country, or that a company or an individual from that convention country want to protect their patent in India, the application that they will be sending will be called as convention application, because they want to protect that invention in India claiming a priority date. So there is a concept of priority date, which happens in all the IPs, be it trademark or patent. So the day when you file your application in any of the patent or IP offices within India or outside, if you are granted that patent, you can claim that priority date, the date which you filed in your country, similar date in another country. So if you go for protection in that particular country, if somebody has already filed something over there later on from the date which you have filed, his license or his patent will be revoked, not yours. So you will be granted a protection. So that's the cover that provides. Another is there was a patent cooperation treaty. So there are many countries which are signatory to patent cooperation treaty, and even India is. So if you want to file a patent in those any of the assignees of that country, any of the members of that particular PCT, you could, through a single application, you apply to the National Patent Office and say that I want to register my patent in all these countries. Through a single application, you can designate the countries where you want to safeguard your patent. So through one application, it may happen. So in a similar way, when in India somebody files, the application may come through any other country. So if somebody using that PCT as a thing and it has come to an Indian phase, it will be evaluated as per Indian laws. There will be no distinction between you, me, and that particular fellow. So that particular application which is coming under PCT and going through an Indian phase, everything remains the same. The process, just by nomenclature, that is known as PCT, National Phase Application. And the divisional application is that if you want to divide out, let's suppose that you made many claims in a patent thing. Now you want to say that, okay, probably I can file another patent out of it. So let me have two patents. Earlier you made an application. So from that application, you can bifurcate it. So you'll have to fill a form and probably give an additional fee for that. And again, if you want to make certain additions to claim that you have already made in a patent application, which you have already filed, which may or may not have been granted by now. So if you say that I want to add this thing to that particular patent, that application is known as patent of addition. So now we'll talk about that, what happens. So whenever you have an invention, what that invention or a patent be, we just talked about. So we need to ensure that whether that is really patentable or not. So we need to file an application. Don't worry, I'll let you know that what is the form type, what is done in that. We'll just talk about it. So the very first thing is filling that particular form and filing it in the respective patent office. So as I said, that jurisdiction of Delhi patent office is for the state within this part. Yours would probably lie in Chennai. So you send your application. Application is form 1. We'll talk about those forms also. Once you submit that form, that application is digitized and recorded, given a number and kept aside. And if you don't say anything, after 18 months, it is going to be published. So when we say published, I hope you remember a little bit earlier, we talked about what publication means, pre and post grant opposition. I hope you remember that. So that publication happens after 18th month when you have filed. So once that is published, so every 6 months, every Friday, this Indian Patent Office publishes a journal. In that journal, your abstract and all other details will be published. That so and so is going to have given a publication, an application for this particular inventions or claims that they have made. So somebody finds that, okay, no, these are not so, we have already done this and that, they can oppose it. 18 months. So once that is published, up to 6 months are given for somebody to file an opposition. And if somebody files an opposition, they get back to you with a letter stating that these are the objections that we have received. Now you need to rectify the same. So you need to answer that, or counter statement you have to file. So when you have to file a counter statement saying that, okay, these are false, whatever you want to say, for that you are given 3 months. After that, the second step is a request for examination. So the essential phases of Indian patents are that you apply, publication, another phase is examination. So we say that examination doesn't happen without your intention. So you need to apply for examination. So once you apply for it, they are going to assign an examiner based on the domain of that particular application. So Indian patent has got many examiners, probably in textile engineering, or let's suppose say computer engineering, whatever it is. So if your claim is with respect to computer engineering, they will give it to the most um, relevant person or examiner. He will go through your application, look at the prior art search. So now there is another term called prior art, prior article search. So there are many organizations which facilitates you before. So you pay them, they will say we'll do that search for you. Even you can do it yourself also. So before filing a patent, I need to do a prior art search that whether this kind of thing has already been published. If something has already been published, it means that there are less chances that I'll get it because somebody is already published somewhere. Not only in Indian patent, in other journals as well. If somebody has published this, probably that is into public domain. So I need to understand that. So that examiner is going to look at public art, do a public search with respect to the patent that you're talking about, what is called as prior art. Look at the claims that you have made. If there are certain things, he will make a note of it, and then he will issue a first examiner report, FER, to you. And you are supposed to file answer to that FER within 6 months of applying. So we have seen that the patent applications, but what we had processed from NIFT, many of we got FER. So we had to respond to them. Of course, we take certain legal help. How legal helps, I'll let you know that. Because many a times we are not well versed with those certain kind of keywords, putting it there and all. So that's where the legal expertise helps us. So we are given a 6-month time period to reply to that first examination report. Once we file it, probably there could be an objection to it. The controller of the patents may say that okay, their objection, or he may say no, that is fine. Whatever you said, that is okay. So if it is said to be okay, then it is okay. Probably I'll be granted a patent, and then again somebody has been granted a patent. This information will be published in the journal of the patent office. And again, if somebody wants to oppose to it, he will be given a 1 year. After that, nothing will be entertained. So if somebody opposes you need to file a counter statement. Probably there could be your personal appearance also there, and need to defend yourself. And it depends on what happens later on. So this is the complete process of patenting. Once you get a patent, you are supposed to renew it. A small fee is also charged to keep it relevant. So till 20 years, it is maximum term is 20 years. After second year of registration, you are supposed to pay fee for every 2 years. Annually. Annually, you are supposed to pay fee. So for first 4 years, as of now, that fee is I think 4,000. Then again for next 4 years, it is 8,000, then 12,000, and then 40,000. So again, that is a slab that government has made, that to keep your patent into force, you need to give an annual fee. So this is the process which looks like. Now, before I'll also let you know that how the application number is given so that it becomes. So are you able to look at the zoomed in screen?
Yes, sir.
Okay. So just an excerpt from the one of the patent application. So this you must be looking at that there is some number written over here, right? 2017 so and 110101010422. So when you file an application, this patent application number is granted by Indian Patent Office, and by just looking at this number you can make out certain things. So first 4 digits are given for a year, so I can make out, I have written Y. So Y indicates year. So looking at the number, I can tell that, okay, this application must have been filed in 2017. So this is YY. Second is J, I have written is J is 1. So I understand that this code is given for jurisdiction, J. 1 is for Delhi, 2 is for Mumbai, 3 for Kolkata, 4 for Chennai. So now I come to know from looking at this J that this application has been filed in Delhi Patent Office. Third is type. 1 indicates ordinary patent application. Second, ordinary divisional patent application. If this number would have been 3, it would have been ordinary patent application of addition, what we are talking about. If it would have been 4, it would have been convention application, and so forth. And last 6 digits are the actual number for the patent serial number, which are allocated by the Indian Patent Office. So this is how you can decode an application number. And on the later side, you must be looking at a number which I have say RYYJJN. So if you have made a request for examination, this number will be preceded by R. So if you are looking at a application number R, it means that you need to request separately and it is located a separate number. So I can differentiate between an ordinary patent application or certain other patent application by just looking at the number of the patent application. I hope this is clear.
Yes, sir. Yes, sir.
Okay. Now we'll talk about filing requirements. We hope we have time. Yeah. So the filing requirements for this are that you make an application in form number 1. What this form number looks like, I'll let you know. Hold on for some time. Form number 2, P is missing here. Over here, there's a typo mistake. It is for provisional or complete specifications. So the difference between provisional and complete specification is that if you are working on certain things, then you expect that you will have certain results from this particular invention or the work you are doing, but you have not final claims, then probably you can file a provisional application. You will get around 6 months to 1 year. After that, you can file a full specification without any extra cost, and your patent will be deemed from, or the date will be deemed from the day you file the provisional application. So many a times we file provisional application, we substitute it with the complete specification later on. So even if you have not got the full results, you can file for provisional application in the form number 2. So just you need to remember these forms, and I'll show you how these forms look like. So if I am having a claim and I want to file it, I'll have to file it an application, that is form 1. Form 2 is provisional complete specification. Fee for form 1 is 8,000 rupees, and government has reduced this over a period of time. And the good thing is that in September 2021 only, this particular government has reduced the fee for 80%, up to 80% for the all educational institutions. Previously, only certain government institutions were individuals were allowed to take this subsidy of 80%. So they need to pay only 20% of the indicated fee. Individual starters and small entities were paying only 20%. percent of the application fee since long. In the latest amendments that were made in the patents rule, which we're calling as patent rule amendments 2021, which effected in September 2021, 20% reduction has been granted to all educational institutions. So probably you can have your own account. You can create your own account, and if you are interested, you can avail these benefits of the same. So you need to have. So instead of paying 80,000, you are just supposed to pay 1,600 rupees only. So in the similar way, if somebody is filing physically, they need to pay 10% extra. So for example, if I'll file form number 1, I'll have to pay 8,000 plus 800 rupees. So 8,800 rupees I'll have to pay if I'm filing as an institute. Then there is a form number 5, which one would like to attach to the declaration of inventorship. Who are the inventors with respect to a patent? Then there is a form number 26, which is what we call as power of attorney. If you are filing it through an agent or you have hired an attorney for it, you need to give this power of attorney to him that he will deal with all the matters. Format will let you know that how that is, what we do in that. So basically these 4 things are required when you file a patent. Form number 1, form number 2, form number 5, and form number 26 if being filed through an attorney. But I'm indicating that you can also file form number 8, 9, and 18 also with it. How it helps, I'll let you know. Form number 8 is to mention, just remember that what these forms are, and I'll show you that how they look like and what to fill in it. Form 8 is to mention the name of inventors in the patent certificate. The fee for the same is 4,000 rupees. And I hope you understand that if you are individual, this would be only 800 rupees. And if you're an educational institute, that also it would be only 20% of this. So if you are filing a patent as an institute, so the assignee will be, the patent will be granted in the name of the institute, not yours. Because Patent Act also says, the patent rule also says that if you are being paid for certain thing, if you are working somewhere, you cannot have the right to those patents. So your organization will have, but you are an inventor. So if you are an inventor, your institute may have certain policies that how they are going to benefit you as an inventor. That is a separate case. But if in addition to your institute, your name has also to come onto that particular patent certificate, Mr. XYZ, in addition to your institute. So for that, you'll have to file a form number 8. You can file it later or at the same particular time. We generally suggest that you file all these things together. Form number 9 is for early publication. So we said that in general, 18 months is a time frame for publishing in India. Publishing what? That you want to have a patent. We said that pre-grant and post-grant publication. So we are talking about pre-grant publication, which happens generally after 18 months. So if you want to fast track it, you need to put a request in form number 9. The fee for that is 12,500. For education institute, I'm repeating again and again, this is only 20% of this because there is 80% of reduction now granted by Government of India. And if you do so, it will be fast tracked. Again, as I said that you need to put a request for examination. If you have published and not after publication only, your application will be examined for the claim and then it is going to be registered. So if you have not placed an examination request, your patent is going to get into vain. So you need to put that application form number 18 and you may indicate whether you want an express examination. If you want an express examination, indicate it. Otherwise, you can leave that column blank. So fee for that is 20,000 rupees. Again, for education institutes, individual, if someone of you have some thing to protect, then probably this fee will be reduced by 80%. So we suggest that or if all these forms are filed at the first stage, you need not to worry about anything. Otherwise, you'll have to keep a track that, okay, later on you'll have to file it. And many times it is also advantageous, because in publication, when it takes 18 months time, publication has got another serial number. Probably your serial may come and it may get published or examined early also, even if you are not claiming immediate examination. So as I already said, that even if you would be sending physical documents, you can check the status of your patent application number granted to you online, because all these documents are digitized. Any confusion as of now?
No, sir.
Right. So this whatever you write, it could be in a simple A4 sheet with a reasonable spacing on the left and right hand side. They suggest that it should be 0.28 centimeters. What to say, the font size, and there needs to be 1.5 spacing, and they need not to be too overlapping. It needs to be a durable A4 size sheet, white in color, not flimsy or what to say, shiny. And it needs to have at least 4 centimeter margin on top and 3 centimeter on the right hand side and the bottom. It needs to be numbered at the last, and on the left hand side, every fifth line of the description and claim has to be indicated. How is it has to be indicated? I'll let you know. I'll show you certain example. So this is the form number 1. So this form number 1 now can be filed online as well, but you need to understand what are the contents. Or if you want to send it physically, that is also fine. I'll show you a filled one also, so that it is easier. I hope you are able to look at the screen. Are you able to see the form or not?
No, sir.
No, sir.
Okay.
Just
Just give me a second. Probably. I'll reshare. Are you able to see right now?
Yes, sir.
Yes, sir. Yes, sir. It is clear.
Okay. I'll show you a field one also. So this is form 1, which talks about that who is the applicant. All these details have to be written. One needs to, I said that form is the same. One need to just take what kind of application it is. So we said that most of the time it would be ordinary. Who are the applicants? So if your organization is filing a patent, then applicant would be your organization, not you. If you are filing a patent in your capacity, then you can probably write your own name. Category of applicant. So a living person is said in terms of IPs as natural person. Other than that, it would be small entity, startup, or an educational institute, or whatever it is, or a company. So if somebody is inventor, they need to write all these things. I'll show you a filled up form, don't worry. If it is being served through an authorized patent agent, he will write his patent agent number and other details. Title of the invention need to come here. If you are claiming a priority date, which we talked a little later, you will fill all these details. Otherwise, it has to be left blank. There are certain declarations which you will sign and put your signatures. And you will select that what you would like to state here. I'll show you that what are the important things. This would be the main important things, that I am the true and first inventor. I am, or we are the assignee or legal representative of true and false inventor. If you are inventors and you have assigned it someone else, you'll tick all these things and reduce and refrain from mentioning others. If it is under any patent cooperation treaty, other things, then only you are going to tick them up. Then you'll state what are the attachments. If form 2 it is complete or provisional, you will say how many number of pages are there, you'll indicate. You need to understand that if the pages exceed more than 10, you will have to pay an additional fee of 1600 rupees per page. So your specification should get completed within 10 pages. Extra pages means extra fee. So, but 1600 is for a company, 80% rebate for an individual or an educational institute. Thanks to this particular government, which have reduced that fee almost 80%. So now it is only 320 rupees per page. Number of claims, how many claims you have made, you'll indicate. Abstract separately you will have to write, and if you have attached any drawings, you will indicate all that. And then sign it and send it to the office. How does a filled form looks like? I'll show you. Are you able to see the screen right now?
Yes, sir.
Yes, sir.
Yes, sir.
So see, this is the filled form. Generally, office has to fill this detail, so we need to fill it, leave it blank. So you must be seeing that ordinary application has been ticked over here. Who are the applicants? You'll write the name. If you are filing from your institute, name of the institute will come here. Who is it? An Indian national or Indian institute? You'll have to write it, and the address. Whether natural or unnatural. So if you are individual, you will take the natural person. Otherwise, you will take the ticket. Now, inventors. Who all are the inventors? So even if it is an institute, there would have been some inventors. Institute is made by people, not just by buildings. So all those inventors' name, their address has to come here. Then title of the invention. Let's suppose if I say it is the AI replacement system. So I'll write it. If it is being sent by an agent, all those details will have to be written, and their address. Then it will write written by or given a confirmation signed by all the inventors. The inventors are saying that I am so and so an Indian citizen, I am so and so Indian citizen, I am so and so Indian citizen. They are declaring to Government of India that the above named inventor is the true and first inventor of this invention, and declare that the applicant herein, your institute, let's suppose say, so you are assigning your invention to the institute. Otherwise, how government will come to know that you have assigned it? Somebody else may say that this was our patent. So they are assigning it to the institute. They have signed it, and so we are saying that inventors are in an application. At times, applicants may be different, and inventors may be different. Many a times this could be same. So in an organization, this may happen. So now, as I told you, need to tick only relevant things. So we are declaring that your institute name, the applicants declare hereby that we are a person of the above mentioned invention. The complete specification relating to the above invention is filed with this application only if you are filing a complete specification and there is no lawful ground of objection to the grant of patent to us. We are the assignee of true and first inventors. Means that the inventors have assigned these inventions to us. So now we hold that right. Following are the attachment with the application. We are saying provisional application or complete specification. So we are writing here that this application is complete specification. Number of pages are 15. Number of description kitne hain? These are 9. How many claims you are making? So in a patent, you can make maximum 10 claims free of cost. Means cost is included in this 8,000 rupees. Otherwise, you have to pay 1,600 rupees per claim extra. So you need to understand that how many claims you are making. Abstract and drawings. And this is also indicating a total 8,000 rupees has been paid, because only for form number 1 fee has to be paid. For this, there is no fee. This application was filed online. I can make out. Why? Because fee is 8,000 rupees and there has been no concession to it. So it is not filed by an individual. It is an old application. Till the time there was no, what to say, 80% reduction for educational institute per se. So I'll not be able to tell you, or somebody will not be able to tell you looking at the fee that what kind of application it would have been, or what kind of applicant it would have been. So again, following the attachment with the application, so we are writing that there are total number of 15 pages with 10 number of claims, and there are 3 drawing sheets. Fee 8,000, and again we are saying that we declare this best knowledge. This is they are the true and all, and it has been addressed to Controller of Patents, the Patent Office at Delhi. So signed by either applicant or the attorney or the trademark agent. So this is application number 1 which we are supposed to file. Is it okay? Any confusion?
No, sir.
Yes, sir.
No, sir, it is clear, sir.
Right. So if somebody remembers that what all we need to file with this, we said that there has to be form number 1. Another is form number 2, which includes the details of your application. Sorry, or of your invention. So I'll show you that. So are you able to see form number 2?
Yes, sir.
Yes, sir.
Yes, sir.
It is, though it looks like a 1-pager form, but it turns out to be a multiple-page form, because they have just indicated title of the invention, applicant's name, and nationality, address. From here, it starts the all thing, preamble to the description. So you need to write what your application is all about, whether it is a complete specification or provisional application. Then you describe your application. Number 4. Number 5, you claim, indicating we claim, then put a date and signature and the abstract at the last. This you attach with form number 1. The claim will not be there if it is a provisional application. So it means that even if you have not got the results, to safeguard your invention, you can file before itself. And there will be no fee for filing full specifications later on, or complete specification. I'll show you a filled form as well. So are you able to see the filled form which I have?
Yeah. Yes, sir.
Yes?
Yes, sir. Yes, sir.
Yes.
So we have just tweaked that form to our requirement. Everything is same. So patent office doesn't objects to it. The only thing is that it needs to be in a A4 size format, needs to have certain margins on left hand side, 4 centimeter on top and right and bottom that we indicated, and double spaced. See title of invention, applicant, preamble of description, what it is describing. So we are describing that it is describing in a manner XYZ, whatever you want to claim. And then from here, your description starts. So you present the field. Somebody may say that it is into the electromagnetic thing or this and that. You indicate that particular field. Then you state a background of what was the background of that particular thing. So you may also indicate about prior art search as well, that this is already happening in market and our claim. So you need to present a full story there. And you may be looking at something is written 5 here. I'll attract your attention and ask you, it is now 15 here. Just keep an attention. I'll tell you what that is. Now it has become 25 and it is 2. So we said that the page has to be numbered in between. And on left hand side, it has to be numbered. Every 5th line has to be numbered. So here, this would have been 5th line, 5th, then 10th, 15th. So it has got 25 lines, this page. Then another page will start with this 5, 5, 10. So this is completely indicating all, see 5, 10, 15. So this is making a background to it. The object of the present disclosure with at least one embodiment herein satisfy as follows. So a complete thing, whatever somebody has done, that is being mentioned over here. To maintain confidentiality, I'm not able to show this thing to you. Then a summary has been indicated. See, you can see that 5, 10, these are just numbers which have been indicated here. Again, whatever the brief drawings are there, they have been indicated. It's good that you indicate what drawings are all about. So it is indicating that figure 1 illustrates circuit diagram, figure 2 illustrates the side view of the machine. And so whatever you want to indicate, you can indicate. And if you have indicated something in that, this is part number 1, 2, 3, 4, 5, 6, whatever, you can list of reference numerals within the image, you can indicate it. This is not suggested by the patent or that you need to indicate in this way, but it's better that you give all these details. Then this detail description is starting about the invention. So invention will differ from people to people. Necessarily, it not need to be such a long application, but it has got certain claims. That's why it is looking like. So it is also talking about technical advancements. Many times people don't put all these things. Why? Because now you need to relate it. What were the patentability criteria? I need to focus them all. So looking at those patentability criteria, we said that nothing will be granted a patent if there is some technical advancement. So I need to find out that. So filing is quite easy. Making a claim and identifying an invention is of main importance. So now on that basis, we said that claim has to be indicated. Now the claim are being made. We claim 1. Claim number 1. And again, you may be seeing that it has been numbered 5, 10, 15, because Patent Act says that it has to be numbered. Every 5th line will have to have number. So it is indicating claim number 1, claim number 2. So if there will be many claims, more than 10, extra fee will have to be given. So it has got, see, 1, 2, 3, certain extra claims. So what will happen when examination, if you are not giving the full fee at the time of when the examination report will come, they will indicate that these were the faults in the, or pay the extra amount of fee. So now the claims have been made and it has been signed. That's all. So this completes the application, complete specification. Then you also indicate abstracts with a title. So basically, being from academic background, you understand what abstract is all about. So in a summarized way, it is disclosing what is patent and its drawing. So probably this abstract also gets notified when the publication of your pre-grant publication happens. Any confusion as of now?
No, sir.
So these are the two forms. I also said that there would be other forms that you will have to fill with it. Does anybody remembers what all forms we talked about?
Yes, sir.
Yes, please.
Form 1, 2, 5, 8, 9 for yearly publications.
Yes,
Like
right.
that.
Very good. Yeah. Right. Thank
26,
you.
28 like that.
Right, right. So I'll get you a glimpse of all these forms. Just give me a second. Since the PPT is not directly opening the hyperlink form, I'll have to open it them separately and show it to you. Now I'll also show you how does the examined report looks like. And you will be astonished to see that it exactly talks in the simplest way that we talked in the initial 2-3 slides. But we said patentability criteria, you will find that it is exactly talking about the same. All right. I hope you are able to see the screen.
Yes, sir.
See, this is declaration as to inventorship, form number 5. So this has to be filed with that, which indicates that who is the inventor in this case, and has to be filed with the application. Form number 1. When we say application, it is form number 1. So name, nationality, address. So it is just saying that I hereby declare that the two and first inventors of the invention disclosed in the complete specification file in the pursuant of application. If there is application number already, so it means that this particular form has been forwarded later on. But we suggest that it has to go with form number 1. So it says that these are two inventors, and they say that we are the two inventors of the same, and it has been forwarded by the attorney of that uh, person who is dealing with it. So it just indicates who are the inventors associated with the invention. I'll show you another form which we said that form number 8. Form number 8 is mentioning inventors as such in the patent certificate. So when patent certificate comes in, so that the names of inventors are also there. Otherwise, the invention will be granted name in the name of organization only. So we are saying that so and so is requesting to add inventor's name in patent certificate signed by this. Nothing else more than that. So just a small query, can you make out from the application number when it was filed?
Two 2019.
Very, very right, sir. And can you make out that where it would have been filed?
Mumbai.
Yeah, very right, sir. And what kind of application it is? It is an ordinary application because it is starting from 1. So as we said that the initial 4 number indicates year 2019. So it was filed in 2019. Second indicates after that year YYY. We said that J indicates jurisdiction. 1 is for Delhi, 2 is for Mumbai, 3 is for Kolkata, 4 is for Chennai. So we understand that this has been filed in Mumbai. And 1 is that it is an ordinary application. Just that. So these are the formalities one need to understand, that we need to file all these at one shot if we are filing. Now it is form number 18. Are you able to see the form number 18?
Yes, sir.
Yes, so we said that form number 18 is for examination request. If you don't fill it, you're not going to get patent. And through this, you can claim for an expedited examination as well. So not an important, nothing complicated thing. It says that everything is written earlier. We are just striking off or putting something else. So this is saying in a statement in case of request for examination, I we hereby request that our application for patent. If you have already filed a patent and you have got an application, then you write like this. Otherwise, you say that I we hereby request that our patent application for patent titled. So you will give the title of the patent. This, which is mentioned here later on. So you will write only title if you are attaching it with the form number 1. So we are saying that it has to be examined under section 12 and 13 of the Act, which says that normal examination. Or otherwise, you may ask for immediate examination also. So this has been striked off. This is saying that, okay, whenever time comes, I don't mind. You just examine it. One interesting thing is that if somebody pays a fee, you have published this, he can also ask for examining your application. That is the beauty, that if you say that, okay, some patent is coming, let us get it examined. You can also ask somebody's application to be examined. And it has to be forwarded. Any confusion as of now?
No, sir.
Now we'll just have a look at the most important thing, that is how the objection comes, and that will throw a light that what an academician actually should look at, that how you can guide yourself or your colleagues or probably even a student when we are looking at a patent application or want to file a patent application. Though we take help of, see, all these long applications have been helped by a legal representative to us, but what has to be put there in form of claim has to be devised by the inventor itself. So it is not just a legal expert can help you out completely. He will be able to help you out in placing in a format that it doesn't get rejected easily. It is in the way the examiners or the uh, patent granting authorities expect. But the knowledge of that, how it can get patented, where are the points where it can get rejected, needs to be understood by the technical person well, because a legal expert is just a legal expert. Within the domain who is patenting, he is the expert matter or the subject matter expert. I'll show you how does a first examination report looks like. Are you able to see it?
Yes, sir.
Right. So I hope you understand that examination will happen only after publication, right? So publication must have happened only after this. Examination request would have been filed and this has come. So this is the standard format, came from the patent office. 1 and 2 are in general things which they would have written that it has been seen and this and that. So it is advising to file the reply at the earliest of early disposal. So this is just a template which you can find in all the applications. The actual thing starts here. Examination report. So now examination report says when the application was filed and above. You can just look at here. Can you see the request for examination number given over here? Can you see this thing?
सर ये लोग आप CSE का ले रहे हैं CSIT?
Hello.
Yes, sir.
What happened?
टोटल 50, 60, 250 के अंदर से
कितने?
250 स्टूडेंट होता है। मैं अटेंड करता हूँ।
Hello.
It is R2020.
Right. So this
Right,
R
okay.
indicates that the request, as we told, that request for examination will be a separate application. So this R means that the request for examination would have been filed in 2020, where the application was given in 2019. So the numbers indicate certain things, so we can make out easily if we understand the procedure. So the actual thing will come here. The summary of the report tells that there were 1 to, I have just marked how many. So let's suppose say 15. So 1 to 15 claims were made in this application. Whether they were correct, this says that no, the claims were not found to be correct, if you can see here. Again, in terms of novelty, in terms of inventive step, and in terms of clarity, they are saying. So they have said that in terms of novelty, claims 1 to 15 are not standing. In terms of inventive step, claims 1 to 15 are not standing. Means none of the claim has standed their inventive step and novelty criteria. And it is also saying that claim number 1 is not clear. Detailed technical report talks, it says that there is a document, this document which they have attached to it, which must have been published here. So this is some patent, it seems. From here I am able to make out. This says that in this document there is a claim number 1. This document, which was published in 18/1/2019, and this claim has already been published, which are again being claimed in claim 1 to 15, let's say. So this is saying that this document already published in 2019 has all your claims. So why are you saying that we should be granted a patent? So now they are saying, indicating in terms of novelty, the subject matter as claimed in 1 to 13 lacks novelty in the view of document D1. So they have indicated this document as D1, document 1. In this terms, when you go through this document, you do not have any novelty in all your claims. And this was published before you, it is saying. And it is also citing that what this D1 has claimed. The document has claimed certain claim number 1, which is similar to all the claims that are being made in your application. In inventive step, it is stating that inventive step being obvious in view of teaching of the cited documents above under reference to the following reasons. It means that it doesn't have inventive step since there is a document D1 which already has disclosed certain things. So your claim is not neither new, non-obvious, and there is no inventiveness in this. So it is saying that your all claims or whatever it is 1 to this lack inventive step in view of documents D1 under section 21J of Patent Act. And it is also saying that principal main claim should sufficiently define, characterize, and clearly bring out the inventive step which is not available as of now. So whenever you make an application, leave application could be made by a technical expert or legal expert. You need to clearly define what you are claiming, and it needs to be an inventive step. Inventive step we discussed in the first 2-3 slides. We'll go there again so that you can relate to it. Then it is saying that multiple independent claims which are made on this basis. So this application which were different were having something 1 to 15 whatever claim. It was saying that 1 was the main claim. Other dependent claims are not clarifying the scope and inventiveness. So it is saying that you need to adhere to it. And it is saying that there would have been certain some document would have not been filled up. Let's suppose a form number 5 or something else. They are saying that you need to fill all those documents. And it is saying that you are supposed to provide a breakup of fees also. Give us a breakup of fees. And it is saying that when this report was examined, what was there with us? Any confusion as of now?
No, sir, it is very
No, sir.
clear, sir.
Okay. So just to give you an idea, again, although patenting seems too heavy and all, we need to focus on all these 3 things. If we are focusing this, all the filing could be handled by someone. We need to understand, you must have seen right now that all the claims were being made with respect to this invention. It means it needs to be a new product or a process. It needs to have inventive steps. You must have seen that maximum claim were saying that you do not have an inventive step. So means we need to understand that whatever claims we are making or description we are making in our description or complete specification number, what we call as form number 2, it needs to give a detailed description of that. What is the technical advance as compared to the existing knowledge, or what is the efficiency that it has brought, and how it is economically significant, what is the impact that is going to make into the market or into the life of the people, and how it is not but obvious. Again, if you are able to do some prior search and cite it, we say that it has nowhere been published. Prior art, what is called in terms of patenting prior art. So if you can yourself indicate that there are certain patents, this and this, which have already indicated, already listed, but ours is better than this, you are making your claim better. Or probably, if not, you can yourself find out that my patent is not adding any value. Why to waste such time? So many a times we receive many applications where people have not referred to any previous publications, and they think that whatever they have got is new. And but when we refer to these 3 things, you can straight away make out that okay, no, this is not going to be patented. Even if you go to someone, if you will go to a legal person, he will charge his patenting fee. So he's happy. If you go, they need many such kind of people who just go to them and say, okay, can you do it for me? They will be happy to do it. They will never say no. Because only an expert will be able to tell you that, expert in that technical field, plus a patent expert will be able to tell you that, is there any lacuna, so that you can cover it up initially. Otherwise, those who charge money, they will say that we'll do everything for you, don't worry. So you'll go, they will place, and they will it will be objected. Then again, they will charge money from you that okay, you need to file this, we need to counter this. So you also need to be equally capable to understand these 3 things. If you are able to understand these 3 things, everything is done. You yourself will be able to find out whether whatever you have done is worth patenting or not. I hope it is clear.
Yes, sir.
Okay. So let me show you that just now we saw an objection, how it was counterfiled, just to give you a glimpse at how counterfile statements are made, just a a glimpse of that, how they are referred. I hope you are able to see the screen.
Yes, sir.
So this indicates a simple letter reply to the examination report. Right? We are indicating that what was the invention, application number, date of mailing FER, etc. and starting here. This is the standard format anybody would be writing like this. So now it states that The submission and amendment submitting are up to the satisfaction of the controller as per provision 15 and request the controller to consider the application in the order for a grant. So we are saying that you please see it. So these remains standard, and any counter statement to FER would or reply to examination would have this standard terminologies. So now it starts. Claim, you may see that it has also been numbered 5, 10, every 10th line, 5th line is being numbered here. So it says, it talks about detailed objections that were indicated. So it says objection of claim under section 21J. It has straight away been taken from where the FER was indicating. The document has been indicated herein after referred as DI D1, which was referred there also. So it in starting that our present disclosure or the patent indicates or teaches whatever. Now it is being stated that how it is different from the D1 where it was being objected. So a long explanation has to be given. And it's saying that we are doing this while D1 is doing this. So you will have to counter yourself, otherwise one will lose the battle. Again, all these things, D1 does not do this and D1 is completely doing this while we are doing this. Obviousness, again, a reason is being stated in terms of obviousness, that how it is not but obvious. Many a times lawyers and all those, they cite certain cases as well. So in law you must have understood that citation many times works well, that somebody so and so, the case between this and that was granted favor in this way. So if you can prove certain things, certain cases, even not only in this, in counter statements of trademarks as well, we cite all these things. So it is being indicated that a person is skilled in in the art has this thing or these characteristics. So in our case, a person is skilled in the art won't be able to find out it easily or whatever it might be, all technical aspect of a particular element. Again, on the objection on obviousness, the applicant is the opinion that there are multiple citations available. This is where in the similar cases it was not supposed to be but obvious. So all these counter statements are being given. So it is said that thus the applicant respectfully submits that where it was written that your claims are not clear. So it is saying that our cases were clear, giving all these things. So they must be taken as such. Will not submit any amendments. They are saying that they must be taken. So this is basically a reply to all that what we saw. So they're saying that all form document and cover changes and should be filed in prescribed. So they're saying okay, duly noted, whatever it is. So all objections are being replied. So it was also written that please provide a detail of fee. This was the question that was read. It is saying that agar nahi denge, if you won't give it, it will be abandoned in such a case. So it has been given that what we did. So there were total number of these many pages. So from this we are able to make out that there are excess pages, because maximum we were saying 10. It is written 2, so it must be 20 or whatever it is. There are certain excess pages. So you need to pay, as we said, 1600 multiplied by the number of extra pages. It is said that it has already been paid on this date. So this is, they are saying that they must have given it later on. They are saying paid on this day. So it was not paid earlier, so this is being paid later on. But again, we said that for an individual and an educational institute, it has been decreased to 80%. So only 20% of 1600 will have to be given. So all claims answered, then you sign it and give it back. So this is the standard way which any would be prayer that may be taken up, we must be granted, all that. This is not in the technical language, this is only legal language. Is this clear? Any confusion as of now?
No, sir.
So just give me a second so that we'll be able to wind it up. I'm really sorry we have extended a bit because it was a lengthy topic. So we were here. We were looking at this, and this form was left. This is just a power of authority or power of attorney. It could be given in a simple page also where you write that the simple language which is written. So this is the standard format on the left hand side, while one can write like this on the right hand side, which is being displayed, which says that I so and so hereby authorize Mr. so and so to act on my own behalf with all that notice and requisition may be served to them. So it means that all notices will now be served to this particular fellow instead of mine. So he'll be, whatever he says, I'll abide to it. It simply means that. So in the initial thing, we were talking about that just having a patent is not important. We need to understand that whether we need to take a patent or keep it secret. That we said that trade secrets could also be a way to get it going. So that's a strategic decision which a corporate makes. But as an academician, we said that many a time getting a patent may put you on top in terms of NIRF rankings and all. So when the all institutes are ranked, the number of patents that is also be looked upon. So probably you may look at from that particular angle as well. But the real value comes when you commercialize that patent, or when a patent has an impact. Probably it could be an impact in terms of social impact or a economic impact. So there could be many patents which comes and go, nobody cares about it. It is just being done for the sake of taking a patent. But the real value lies when you are able to commercialize a patent. So we expect that as an academician, we also promote our student to solve problems through patenting, not just look at that, okay, anything for the sake of thing we are patenting. As we are saying that one of the things which is very important is that as a corporate, one may decide that whether to keep secret or patent, because patent may have certain glitches. One of the main thing is that after 20 years, it comes into public domain. After that, you no longer have a control over it. Again, many a times people may find it tedious that it has got multiple phases and it takes time to get it granted. Even with the faster pace that government has given a thrust, the result has to be seen now. So in that case, what happens that people generally go for an alternate way. For example, you must have seen that Coca-Cola has got a trade secret for its recipe. Otherwise, that Coca-Cola, the making of Coca-Cola could have been a patent, and after 20 years, it could have been lost. 20 years. But it is keeping it going because they have made certain efforts to keep them secret, and it is such a commercial recipe that it has given a success all over. So it was a combination of a trade secret and a trademark. So in the similar way, if somebody you guide your students, or even when we guide our students, we give them then this kind of thing, that this is the key decision one has to take, that whether to patent or keep it secret. And even not in terms of patents, there could be many things which people generally don't know that these could be a valuable IP. Even a list of vendors could be a key IP in terms of trade secrets. So how you maintain that, how you keep that secrets, you need to understand. And probably there could be many things like signing non-disclosure agreements to it, which can really help us out. So I hope one can move it. Another thing is looking at whether we restrict it till invention or take it to the innovation level. Innovation, when it, as I was saying, that when it has got an amplified effect on the masses or people. Otherwise, invention remains invention, it comes and goes. So we need to also look at that, how it can be made useful, or how can it have an impact over the society or the people per se. For example, there is the famous example that one can quote for it would be that you must have seen that radio waves were invented too early by I think Hertz was the first who invented them, radio waves. But actually, they were radio waves, nothing else. We read it that he invented that. But the actual impact or the advantage was given by innovation. The thrust that innovation gave was when I think this a wireless communication or wireless telegraph was used by Marconi in the later 1901 or something like that. So that was invention when it was put to actual use, and even that he was granted a patent for that thing. So he combined it with certain other newer things and was granted a patent. So in terms of patenting, we need to keep focus on our students that, or as an academician ourselves, that how we can find out newer things, and at the same time we also should look at how it can be socially useful in a way that it could impact to the, or the benefits could be given to the masses. Otherwise, that patent is just going to increase the ranking of your institute, but it is not going to actually help the masses at large. So we need to look at commercialization of patents. If we are able to get that, can only happen then when that patent will hold value. So commercialization will not only help your institute in gaining certain what to say revenues, but it is also going to impact the life of others. So that's what the real essence of patent would be. I have taken too much time, so I'll rest my case. Just a bit about the international things. So as we told that India is a member to WTO, and it is also a member of PCT and all. So all those, if somebody wants to go international, that can be done by under this PCT or Paris Convention. All the countries that they have, through one application, one can designate all those countries and probably get a patent. But before that, it is really quite relevant that we patent within our own country. Then probably one will be able to go outside, because first of all, you will have to get a patent within your national patent office. So thank you so much for giving me this opportunity. If you have any queries, please let me know. I'll try to answer them with the best of my knowledge, because I'm actually not a legal person, but still from academic point of view, I'll try to answer.
Yeah, thank you so much, sir, for giving a brief about the patent. Dear participants, if you have any queries, Deepak sir is ready to answer. You can unmute yourself and you can ask. Sir, I don't think that the participants will ask the questions, because you clearly explained about each and everything from the beginning of the patent, sir. So what will be the patent, and where we have to start? What are the different types of forms and all? And what may be the objections, and what happens if we have any objections? What are the safeguards, and how many types of applications that we have, and what is the procedure that we need to follow for applying the patents? And you focused different types of forms, like form 1, and how to go with the form 2, 5, 8, 9, 18. I hope due to lack of time, you are not able to explain all these. That if time permits, definitely we will go with the remaining one also, sir.
Right.
Really.
One little thing I would like to add, that I was talking about prior art search. So Indian Patent Office gives this as a feature of public search. So you can log on to ip.gov.in and probably key in your keyword, whatever field you are working with. It will give a list of patents that have already been granted or are in the verge of granting or published. So you can refer that. And again, Google has also come out with its application called Google Patents. So you can do a prior art search there also, so as to compare your invention, that whether it has been published somewhere else or not. So probably if it has been published, or somebody is claiming such thing, you will be able to modify your application or probably work out something else.
Yeah, definitely, sir. Definitely, all participants will do.
So
Yeah,
thank you. Thank
sir,
you so much for inviting me.
Sir, thank you so much, sir. Before that, let us take one group photo, sir. Dear
Sir,
participants. Yes,
can you share your email ID, sir, please?
Yeah.
So,
So I think I'm not able to chat. I'll it is Deepak DEEPAK Deepak.joshi Joshi
yes,
@nif.ac.in
at the rate.
NIFT.ac.in.
Thank you, sir.
Sir, I have one question.
Yeah.
Sir, can it is possible that we can go for a pattern by ourselves without any agency's help?
Yeah, why not? You can always go yourself. So for that, either you can file physically. So you
Okay.
the form that I have explained, you fill them and go to make a demand draft in the name of patent office where you are submitting. Probably yours jurisdiction is the Chennai one, and you can submit your application yourself, or otherwise you can create an account in the e-filing portal. For that, you need to have either digital signatures or e-signature. So
Okay.
e-signature
Okay.
is easier. E-signature, you need to file it with
Okay.
e-mudra by OTP, as you might be verifying your Aadhaar. No, somewhere you take a mobile phone, they said that okay, Aadhaar OTP will come and verify. So in the similar way, you will have to verify. You must be verifying your income tax return. In the similar way, it gets verified. You need not to carry that dongle for digital signature. So that has been simplified, that process. So just you need to create your login ID, and all these forms will have to be uploaded there, and you e-sign it. That gets very well. And even once you are signing, it will ask you whether you are an educational institute or you are a natural person. So if you are a natural person, automatically it will take that amount of fee. So you can pay that fee by debit card also there. Otherwise, physically you will have to pay just 10% extra, and demand draft will do, or even check
So
will do.
what will be the minimum cost which I have to incur if I am filing manually?
If you are filing manually for the fee is 8,000 rupees for an entity. For individual, it is only 20%, 1600. 1600 ka 10% almost 1750 or 1800 rupees it will take if you file physically.
Okay, sir. Okay, sir. Thank you.
Yeah.
Thank
Sir,
you.
maybe
The session was informative.
Sir, one question.
Right.
Just a confusion about the applicant and inventors. Many times when we are associated with the institute,
Good
generally they are asking that
Hmm.
it should be in the name of institute.
Right.
So what is your suggestion?
Indian laws. If you go by Indian laws, if you have been paid for something, let's suppose say I'm a teacher at computer science department, and I have made something within the use of institute resources within the institute's time.
Right.
Even if I file a patent myself individually,
Right.
my institute can claim no, it should not be granted to him. It should be granted to me because I have given him salary, and he has done within my time permit. So many institutes have IP guidelines already. If your institute doesn't have, probably you can work out framing an IP policy for the institute. So this is the thing where people are not aware about the things. These kind of mistakes happen. So if you are able to justify, let's suppose you said that okay, I did not use institute's IP, I devise all these things at night. If you have claimed, then probably you have to counter them. No, because I have not utilized your resources. But if you are doing within the institute, utilizing those resources, they are giving you salary, the applicant will be the institute itself. You will be designated an inventors. But yes, your institute may have certain policies to promote you as an inventor. They may say, okay, if it gets commercialized, we'll pay you this much, or 5%, 10%, 20% of the or they can say that okay, to promote inventions or to promote IP creation at institute, whenever an IP is filed or invented by an inventor, we'll give him promotion, or we'll give him a salary hike, or we'll give him something. So that is the institute's way of promoting IP.
Okay. But suppose I am working in first institute, and maybe after 5 years, 10 years, I have been promoted and I left that institute, then what will happen about that patent?
So again, that's what I'm saying. The owner remains the institute. You are not. You are just inventor. They have paid you.
Okay.
It's as simple as that. I was a carpenter at a retail store. They asked me to make an almirah within the store shelf something, and I resigned. So can I take that almirah with me? No, they gave me salary for it.
Right,
Isn't
sir.
it?
Right, sir.
But if
Okay.
the institute has a policy, if somebody has made a patent, he or when it is so, what will patent? Getting a patent is not going to give you money. Only commercialization of patent is going to give you money. So so that's the institute has to think that if they commercialize any patent which is of importance, then what is going to happen? Whether inventors will be given a share or not. So many of the institutes, our own institute also has a policy that they will be given a share. So they will be motivated to do. And even when they leave the institute, if I have such a policy, that share will be given to the a particular person. Even he leaves, even he goes out of this world, and God's in the into the heaven, then his next kids and kin can enjoy the benefit of that. So that institute will have to frame that policy. Otherwise, going by the national laws, if you have been paid for some work, you cannot claim for it.
Okay. Yes, sir. Thank you. Very much clear.
Yeah, thank you, sir.
Yeah, thank you so much, sir, for clarifying all our doubt. Dear participants, I request you to enable your cameras so that we will take on group photo. Please stay as it is till we intimate, please. Yeah, thank you so much.
Thank you, sir. Thank you.
So by this, I'll mark end of this impact lecture series. So let me convey a vote of thanks to, first of all, let me convey my thanks to Sri Vishnu Engineering College for Women Management. Our principal sir, vice principal sir, and head of the department, Dr. P. Kiran Sri garu. And I must thank to AICTE, IIC, and MHRD Innovation Cell for associating with us to conduct this impact lecture series. And I thank Dr. Deepak Joshi garu, despite of his busy schedule in his weekend, he spent more than 2 hours. Really, it is a great opportunity for us, sir. Being such a busy person, you spend more than 2 hours for our participants. Really, they are blessed, sir. Really, thank you so much, sir. And I thank each and every participant one to one for making this program more success with your participation. Really, we thankful to you, one and all. So I once again from the Department of CSE, Sri Vishnu Engineering College for Women, Bhimavaram, we thank you all for joining with us in this impact lecture series, and we hope the same support will be continued for further enhancements also. Thank you so much. Thank you one and all for joining with us. Thank you, sir. Deepak, sir.
Thank you, sir. Thank you, sir.
And participants will share the feedback link. Please do fill it.
So how will you share that feedback link?
Yeah, we shared the feedback link through WhatsApp group, sir.
Okay.
Sir, I shared it, sir. Just please check it. Thank you so much.